for those of you who missed it, there was a part one. This is a part two. We did go through some of the background of the wage parity law in that first session, so I will do a little bit of that as well here today because this industry is constantly changing. There are newcomers all the time. Sadly, there are people who leave the industry, and I've had the pleasure of working with those folks for such a long time. It is bittersweet that there's so much turnover in home care. But there are new people, so I want to spend just a few minutes talking about the wage parity law itself. So for those of you who have ever dealt with contractors who may have government contracts, you may find some parallel between the laws that impact those government contractors and Medicaid providers. There are compensation and benefit standards that are generally referred to as prevailing wage laws. And those prevailing wage laws dictate that if there is a contract in place between the provider, either a healthcare provider or a contractor, and the contract is with a government entity, that contractor agrees to certain terms and conditions as a condition of having the contract in the first place. So, for a contractor who is building a new correctional facility in upstate New York and it's a multi-million, multi-year project, as a condition of receiving that work, they agree to pay their workers, all of them on the job, engineers, plumbers, electricians, etc., a certain minimum wage plus a premium on top that is for benefits. And so there is this long-standing in the U.S. Area of prevailing wage laws. And in 2012, the New York State government passed the wage parity law, which the structure is very similar to prevailing wage requirements in the construction industry. And so for anybody that contracts for Medicaid services, not with New York State though, MLTCs and MCOs contracts are covered as well. Those contractors, the LICSAs and previously FIs, have to agree to pay the workers a certain minimum wage and provide a certain amount of benefits. Now, that law was passed, as I said, in 2012, 2011, 2012, and it was phased out slowly. Initially, it was based on the SEIU 1199 contract, largely because the law was passed with the SEIU's influence. And so the initial iteration of the law said that covered employers could satisfy the wage and benefit provisions of the law if they followed what was in the last negotiated collective bargaining agreement between the LICSAs, whose employees are represented by the SEIU 1199 union, and they provided those same types of benefits and the structure. The law evolved, and as of 2016, the law did not look to the 1199 contract as the model for how providers, covered providers, could meet their wage parity obligations. You will also see that there have been FAQs and guidelines that were issued by the New York State Department of Health throughout the years that are still, according to this last set of changes, valid. And so as you're working on the LS300 and the 301s, you will see in the guidelines issued that the state is directing you to the FAQs that were issued in 2011, 2012, 2014, when the wage parity law was a new thing and there were a lot of questions. And then in 2020, there was another change to the law. The legislature was inundated with complaints that there was a lot of fraud in how the benefit piece, particularly, was being structured by covered providers. And to provide greater transparency to the workers about the wage parity law, as well as to provide some accountability to the state about how the benefit structures were being formulated, we got this amendment in the law, and that produced these forms. So one of the requirements that came out in 2020 is for LICSAs and FIs, covered providers under the wage parity law, to state in writing at the time of hire what the wage and benefits are going to be. And then that had to again be stated on the employee pay statements. So for those of you that are wage parity covered, those are kind of at the time of hire and ongoing documentary obligations that have been in effect since 2020. You have to specify what the benefits are. You have to divide them up. Even if you're providing them as a bundled service with other benefits, you still have to break them up. So that obligation has existed since 2020. The other obligation that came out in that law, just as we were all dealing with COVID and the regulatory requirements with that, had to do with reporting and auditing your wage parity spending. Not necessarily accrual, but actual spending, because there had been at the time a number of investigations at the Attorney General level where there were allegations that this money was being paid to providers and it was not really being spent on aid benefits under the wage parity law. So, to kind of force some accountability and transparency in how providers were spending the reimbursement and the wage parity benefit component of that reimbursement, we got this reporting, accounting, auditing requirement in the law. And then a few years, it was years later, we got the forms that were to be used to report and audit providers to ensure compliance with wage parity. So the forms that came out were a bit problematic because they required the auditors to follow procedures that were not really consistent with regular auditing procedures. I am not an accountant, so and the accountants on the line here, please do not educate me. I fully acknowledge I am not an accountant, but the process by which auditors were supposed to audit the wage parity compliance of the providers was inconsistent with the professional accounting standards by which auditors do audit businesses, not just wage parity businesses, but all businesses. So there was a tension in what the state commanded of providers through their auditors versus what the auditors could provide within their own licensing. And so the auditing associations in New York State really lobbied New York State for years to change what the expectations were for these auditors, because with the exception of a few, the overwhelming majority of CPAs and auditing firms who engage in this type of work refuse to sign off on these forms and refuse to complete the audits the way that the Department of Health was envisioning it. And to me, it's a little bit funny because there's constantly a tension in my world between what the Department of Labor requires versus what the Department of Health requires. And so I'm always talking about this is the DOH world versus the DOL world. Here with these LS300 forms, we had the DOH publishing the forms in collaboration with the DOL talking about accounting standards. And so there was clearly, obviously a tension, which could have been avoided had the DOH and DOL consulted the accounting and the auditing associations before they published these forms and standards. But nonetheless, because the New York State Society of CPAs made such a compelling demonstration and argument that the forms and the auditing process as envisioned originally was not compliant, not feasible, and inconsistent with the professional standards for accountants, the state did put these forms on hold. And so for the last several years, providers will attest to this. They have perhaps been asked for the LS301 forms by the payors, but they didn't have them to provide. And because most CPAs did not want to sign off on them. And so the industry, the home care industry, has been waiting for years to get new guidelines and some sort of reprieve for their auditors and accountants so that they could resume this entire process. So on March 9th, we did get guidelines and kind of an explanation of a new process. And before we jump into the presentation of today, just a few housekeeping items after that intro. I am an attorney, but please do not consider anything I say today as attorney-client privileged advice or counsel. For your own specific forms, please consult your attorney. Obviously, you have to work with auditing and accounting professionals to meet your obligations here. But as I will talk about, for some of you, be very, very sensitive about what you say in that context, because there is no accountant-client privilege. And so again, the law has evolved. It is not very intuitive. And so it is easy to make mistakes in trying to comply with the wage parity law, the Department of Labor laws that apply to home care providers, the nuances and the ever-changing requirements and standards of those. Mistakes are very, very easy, but because we're talking about Medicaid money, there's always, always this threat and overlay that someone would go to jail, your money would be taken back by the state, and you would lose your license to practice this business in New York State. So the implications of a paper error are much, much higher in the home care space in New York State than perhaps anywhere else in the country, except perhaps California or Minnesota at this point. But the implications of could be clerical error are much, much higher. So if you have any concerns about what you may have done in your wage parity space over the last few years, and we'll talk about which years are covered by these certification requirements, make sure that you loop in your attorney and seek some way of making the documents and the communications and the prep process privileged from discovery. Attorney-client privileged. Again, there's no accountant or auditor privilege. And then, so today we will talk a little bit about what the administrative requirements are. The guidelines are actually pretty long. I do wonder if at this point they had an accountant write this because they're so long. So I'm going to go through things that stood out to me that I thought were interesting. I've started working with a number of clients on preparing these, kind of cleaning up some things. And so I will go through what I thought stood out to me as potential challenges for you as you're working on these things, not only for this year's certification, but going forward. So we have two forms. We have the LS300 form and the LS301 form. Neither has changed. I want to be clear. You will easily find online 2024 versions, and we'll talk a bit about what those forms require. So the forms for 2025, we're 26. So last calendar year, they are due on May 31st. The forms for 2026 and forward will be due on June 1. So next June in 2027, you will be submitting information about your benefits and wages for the calendar year 2026, and you will be submitting that by June 1. Last webinar, we really went into detail about who is owed what and when, CHA, MCO, LICSA, FI, etc., single FI, etc. So I'm not going to repeat that on this webinar. I will say that there have been questions about the forms due for 2021 through 2024. The guidance that came out on March 9th is silent on that point. I've emailed the state to see clarification. I have not received it. I know there's a bunch of you who are in the auditing and the accounting space on the chat. If you have reached out to the state and they have responded on these years, by all means, please put it in the chat for us. I guess another housekeeping item as we're going through this, please put your questions in the chat. I will try to address them as we go through this, and if I do not, I will take some time towards the end of the presentation to read through the questions in the chat. Okay, so let's talk a little bit about this form. All right, so the breakdown for your expenses, the wages and the benefits, all of that is here. It needs to be reflected on LS300. Now, the certification for 2025 is what we're talking about now, because that's the one that is most currently due. If you have submitted the 300 and 301 to MCOs for prior years, again, the majority of accountants did not want to audit and do these, but if you had an accountant that did and you have submitted it for prior years, you do not owe forms to those plans for those prior years. And again, I mentioned this on the last one, but I just want to reiterate. So a number of you did reach out and say that you had submitted them in the past. Great. You're off the hook for those prior years. The ones who did not submit them because you work with an accountant that was not comfortable certifying the LS301, then you do have to complete 20 the years 21 through 2024. But again, when are they actually due to be submitted? It's not stated on this particular document, and I assume that the MCOs who have their own independent obligations to the state will be reaching out to providers to request them. So they may be imposing their own deadlines. And just to be clear, a question that has come up very often over the years when the plans request the certifications, they can always request them sooner than the deadline imposed by the state. Okay, so LICSAs, former FIs, have obligations of their own, but those obligations are set by law. MCOs, because they have a contractual relationship with you, can set earlier deadlines, and they need to review those forms. And there's a big, big question about how much due diligence they actually have to do with the forms they're getting from you. Um, but they need time, right, to review that before they can certify to their own compliance to New York State. And so do not be surprised if the plans are requesting and expecting these sooner than your deadline. So for example, the 2025 compliance deadline is May 31. So a plan could be asking for your documentation much sooner than that because for the 2025 year, they have their own certification that's due on May 31st. Okay. Um, so those were the screenshots of the form. I want to just highlight a few things. So the first item that you have to identify is all Medicaid billable hours worked by the home care aides, regardless of whether they were or were not overtime hours. This is home care. So there's always a question about what is billable, what is authorized, what is actually paid out as wages. What this says is all Medicaid billable hours worked. And so this requires all work time that is a Medicaid billable hour. So it is not in service, for example, which is a hour of work, but it is not Medicaid billable. However, it does beg the question of if the patient received hours in excess of the authorization. Um, it doesn't say authorized, it does say billed, but but it also says worked. And so the first question, and again, I haven't received an answer to this one, but I suspect I know how the state's going to respond. The first question is, what if someone worked in total 5 hours more than what they were authorized to work? Do we report it? It was patient care hours. If it was paid, it should have been paid with wage parity. But many providers only pay the authorized hours, the hours that they can bill. And so even in the first instance, what hours you're reporting is a question mark. And you're using EVV to track all this time for 2025. I'm sure there's a portion of it that is timesheet based, but you have those hours. You have the raw hours and you have the paid hours. So the first question that you need to discuss absolutely under attorney-client privilege, because you may be making admissions that you haven't paid all hours you're required to. And your accountant or whoever is preparing this for you may be the one to first ask, what am I using here? Am I using the hours, the raw hours that you collected, or am I using the ones that were revised before they went to billing? So, like I said, we're going to go through this on the points that I find could be an area of challenge for you in completing the form. We're not going to go through everything one by one, but please put your questions in the box. The total wage parity expenses. So this is total hours. Again, we don't know what the hours are, times the wage parity obligation. So this is adding up the 254, the $1.67 times the total hours. The base wage. Now, let me just show this. And I'm sorry, before we go to three, I just want to talk about number two for a second. This is asking for your expenses. So this is the amount that you incurred. This is not the actual amount that you have paid out. This is your highest accrual vested obligation. Um, for the accountants, I know that's not the correct word, but this is your maximum exposure and obligation based on the hours and the 254 or the $1.67 from last year. Now, for number three, where it talks about the lowest wage parity base wage rate. So a lot of you will put on the LS62 form the home care worker minimum wage under New York City or Westchester. But there's a question about if there are multiple rates. And so if there are multiple rates, then the guidelines that are still here talk about putting in a range of the wages. Excuse me about that. So there will be guidelines in the guidance that was issued on March 9 that talk about multiple rates and how the auditor is supposed to address those. And we'll just cover them in a little bit. But keep in mind, you are likely to have a lot of questions because the reports are going to show rates all over the place. I know because the reimbursement rates are what they are, many of you are paying at the minimum wage rate, but there are all sorts of exceptions where premiums are paid, and we'll talk a little bit about how that's addressed. PTO and other benefits. So for purposes of this form, I just want to be clear, they're asking for the accrual rate and other benefits as well. So they're asking for the um, per hour accrual rates for for a lot of these benefits. Um, and this is because when the wage parity law went into effect, it was based on the different buckets and the accruals, the value of the benefits that were being provided to those SCIU 1199 workers. And so the state is still referencing the FAQs that were issued when the wage parity law referenced the CBA of 1199. And so you see that the state, in issuing this guidance in 2026, still hasn't moved away from that. They're referring to FAQs issued under the 2011 version of the law. So keep in mind that disconnect is there. And I've already addressed why these forms are important. I'll talk about them again, but keep in mind this. The guidelines from the state are simply guidelines. This has very little value actually in a court of law. It has a very little value with the Attorney General's office or with the Office of Inspector General at the U.S. level. Medicaid dollars and this program is a state program, but the feds absolutely have the authority to enforce it. And so if you are in a court setting, you are not in a setting where the Department of Labor, the OMIG, is coming after you, but you are in a court setting because this could be enforced by a private individual as well under the labor law. A home health aide could claim under the False Claims Act, under the labor law, all sorts of violations. And so your compliance or non-compliance with the FAQs it has questionable value. So do not just accept the guidelines of New York State, which, as I said, are a bit inconsistent with the current version of the law. Do not accept this without challenging or questioning how it may appear in a different forum, such as a court of law. Um, so just because you're following this to a T protects you in certain forums, such as the New York State Medicaid program, perhaps. You've satisfied your obligations to New York State Department of Health. You've satisfied your obligations probably to the Department of Labor of New York State and OMIG. OMIG will defer to these guidelines. But there's a whole other world and forums out there where you complying with this March 9 guideline doesn't really protect you. And so just keep that in mind. You are not necessarily safe from liability and legal exposure just because you follow these documents to its T and crossing the T's, dotting the I's. Okay. I want to talk a little bit about the LS301 form. Again, it's the same. If you read through the guidelines that were issued, there's a lot of emphasis on documentation and the LS62 statements. So, as I said at the outset, when the wage parity law was amended in 2020, there was a lot of emphasis on transparency of the wage parity structure, especially the benefits for purposes of giving the aides clarity on these funds, as well as giving clarity to New York State and probably 1199 other third parties who have some interest in how these millions, billions of dollars at this point are being spent. And so the LS62 statements really came out as a result of that 2020 revision to the wage parity law. The LS62 statements must be given at the beginning of employment to home health aides, wage parity covered aides. There's a different form that is used upstate for hourly workers. But so LS62 is directly tied to those wage parity covered employees. Now, I'm sure most of you know, if not all of you, what is on that two-page document that's issued. What I wanted to emphasize is that in the guidelines that came out from New York State, the auditor is supposed to look at all sorts of documents in order to confirm what the numbers and the data show. One of the things they're supposed to look at are the LS62 statements. So you are supposed to really dust those off every few months. The law changes very, very frequently when it comes to home care industry generally, and the minimum wage changes. Now, if the minimum wage is simply increasing, you do not have to issue a new. These were called Wage Theft Prevention Act notices. You do not have to issue a new LS62 if you are only changing the minimum wage. So for the last few years, we've had the wage parity law and the minimum wage law changing and increasing the aides pay rates by about 50 cents. You do not have to issue a new form every January when the rate goes up, if that is the only thing that's changing. If, however, you've been paying everybody significantly more than minimum wage, and now you need to decrease the rate, you do have to issue a new form, even if that happens during the year. If you change the benefit mix, right, out of the $2.54, perhaps you had previously given $1 into the health insurance. Now you're going to be giving $1.50 or 50 cents, and that is affecting how much you put into the other buckets out of the $2.54. You do have to issue a new form at that time as well. These are just notice forms. They do not require consent. The employee is supposed to sign it. If they do not return a signed version of the form within 7 days, your HR office has to mark it as not returned signed and file it away. All right? But your change can go into effect even without the employee's signature. You do have to send the form out though, if there's a change, reshuffling of the benefit value or a reduction in the pay rate. And that happens anytime the change is supposed to happen. 7 days before the change is when you're supposed to send the form out, okay? And again, just because the employee doesn't sign it doesn't mean that you cannot enforce or implement the change. But you are supposed to document on the form that the employee did not sign and return it. So LS62 are now a big deal again. And I spoke about this the last time on the webinar, but these forms are also pretty significant in the whole wage and hour class action labor law world because mistakes on pay statements and mistakes on these LS62 forms have a per employee per pay week penalty, a maximum of $5,000 per employee. And so it's really important to get the information on these forms correctly. At the very least, like I said, your HR department should be reviewing these at the end of every year to make sure nothing has changed to require a modification to the template version of it. Um, Auditors through these guidelines who are working on the LS301 are also required to look at other HR documents, and I'll talk about that in a little bit, but there's just a lot of emphasis on paper, right? Practice is very important. Procedures are very important, but as all of you know, this industry is very, very audit heavy. And again, the implications of a bad audit are expensive and could be criminal. But the emphasis on paper is really evident in this guideline. So I encourage you, if you have not spent the time, and I know it's difficult to find the time these days, but I encourage you to make sure that your HR department is on top of all of these changes and updates and has a system in place where they are reviewing and pretty regularly updating the necessary documents. And then the last point I wanted to make is the one I had made earlier, and we did get a lot of people signing in after I had made that point. So once again, for the newcomers to the presentation, there's no privilege in communications between employees, directors, managers internally, and there is certainly no privilege between them and the outside accounting or auditing firm who has been brought in to help you with this process. So if you are an agency that is a bit concerned, um, and there's nothing wrong with being concerned, everything could be perfectly fine, right? You could be concerned, and you could be perfectly compliant. But if you have any concern about non-compliance, given the implications of a bad audit or bad paperwork or the narrative that bad paperwork could create, be very cognizant of what you're saying. Maybe say less. Certainly try to say anything that needs to be said in the context of attorney-client privilege, if at all possible. All right, independent auditor. I just want to talk a little bit about this, and this is from, this is not my definition. I did that little disclaimer as well. I am not an accountant. I have other certifications, but not that one. So this is what constitutes an independent auditor, right? There's a lot of people that make money off of home care, and you have to pick the right person with no conflict. And here are kind of the definitions of what would conflict someone out of doing this type of work for you. But this does need to be done by an independent auditor. And that independence piece is actually statutory. So I mentioned earlier that the guidelines here are inconsistent with the current version of the law. And so I kind of bring you back to the point of the law. While the guidelines have been revised and, in my opinion, are still a little bit loosey-goosey when it comes to some of these very, very important things, the law itself requires an independent auditor. And so if there was a question about the legitimacy of the audit, of the certification that you were issuing. And this question could come up from an MCO. It could come up from the state. It could come up in a False Claims Act action against your agency. You want to be able to stand behind the firm that you've selected and that there truly is no conflict. So just give some thought to this. The LS301 form. Okay, so note that the auditor is not actually signing this. So still, the obligation for everything remains on the provider. And I love outsourcing work. I love delegating work. But I always say to myself, and I say this to clients as well, the responsibility is always yours. There is really no way to outsource things, especially for you who are here, for example, affirmatively the ones signing off on this, but also where the implications are so high with federal and state funds flowing and being your livelihood. So do not simply delegate this work to someone. Make sure you are an involved participant in this process. But so this is the form. And I just want to talk a little bit about this. And look, there's the independent auditing firm emphasis here on this form. I want to talk about some takeaways from this LS301 process. So we talked a little bit about the documentation being consistent. So, and you'll see there are guidelines on how the auditors are supposed to review your pay time off, personal time, vacation, sick, etc. Um, if there are discrepancies between the accruals, for example, and the payouts, and the rate at which some of these benefits are being paid out, and that is inconsistent with the accrual methodology in your documentation, the auditors are supposed to be questioning that. So make sure things line up, okay? PTO, sick time, paid leave, like all these things that accrue, they accrue on the basis of the value of the minimum wage and the wage being paid. And so uh, I know many agencies, they do not update their PTO policies on a regular basis. They certainly don't update them every time minimum wage increases from year to year. And so this is an example where there could be an inconsistency. And maybe it's an even bigger problem. Maybe you haven't updated the accrual in your payroll system. So the value of your accrual needs to change. And so how much credit you are taking for accruals for purposes of wage parity will change when the minimum wage law changes. Your policy has to specify the accrual rate and methodology. So that has to be updated as well. So when these things are being audited, make sure things are lining up. This is what I mean by being clear, being consistent, and emphasizing that the documentation has to clarify these inconsistencies. Your auditor may very well ask you to update a policy before they will say or complete their audit. So again, there's not a lot of time to do this for 2025, in my opinion. So if you anticipate that this might be an issue for you, then start reviewing if these things are lining up, and then start updating your policies before being asked to do so. So we talked about the PTO, sick leave, and other paid leave, and just an emphasis that the guidelines from March 9 still refer to that 2012-2014 guidance from the DOH when the wage parity law was a relatively new thing. I don't know, frankly, how much that would fly in a lawsuit, but okay. Um, Holidays. So for those of you who are paying premiums for holidays, same as differentials, there needs to be a written policy for those. I know with the collective bargaining folks that there are provisions about what the value is of the holiday, how they accrue, who gets paid, et cetera, et cetera. But for those of you that are not necessarily, your employees are not unionized, make sure you have a holiday policy that not only talks about who's eligible for it. Most policies on holidays will just say time and a half or double time for holiday work, but they're not going to talk about, well, this is a wage parity benefit, for example. And this is the value that, and this is how we calculate it into the whole wage parity mix. So that whole process needs to be in writing somewhere. It could be part of one whole document. Our obligation is $2.54 per hour. This is how we meet it. And you can reserve some discretion in that policy. For example, if you're not taking credit for spread of hours pay, you should. But that's an example of where flexibility in the policy really benefits you, because you don't want to overpay for wage parity benefits. So if you are paying spread of hours, and I've talked about that many times, for-profit home care providers are definitely covered. Some nonprofit providers are also covered. But if you're paying spread of hours, and that fluctuates, right, depending on the pay rate and the hours, you want to take credit for that. Meanwhile, you've issued an LS62 form that breaks down the 254 pretty precisely. So in your LS62, if you are a provider who's paying spread of hours, you absolutely want to mention that there could be other payments throughout the year that could change that mix, such as spread of hours, such as holiday premiums, et cetera, et cetera. And your policy needs to say that as well. So just like you would have a summary plan description for non-HHA employees, I'm envisioning something like that when I say you should have a big picture policy that breaks down each of your benefits and the 254. The LS62 is theoretically supposed to do that in a very simple two-page form. But I don't think it does. So differentials. So differentials are an 1199 concept. And again, the guidance that is still out there and still being referred to even in this March 9, 2026 DOH document is referring to differentials. But there's nothing stopping other non-union employers from paying differentials. And differentials are simply premiums for specific type of cases. Mutual cases, weekend cases, difficult to serve, remote cases, etc. You can take credit under the wage parity law for providing differentials and paying them. But again, make sure that your documentation explicitly recognizes that as part of the whole benefit obligation. And then additional payments category as well. So when the law changed in 2016, it really took away this distinction between additional and supplemental wages. There was just a wage and a supplement. That's it. Um, Two categories. And yet, even in this March 9 guidance, this is what I mean. The guidance doesn't necessarily follow the law. It talks about three categories. Uh, there's wages, additional payments, and then the supplemental wages. So it's a bit, to me, it's not very clean. But, um, this category of additional payments absolutely is creditable by providers who pay these benefits. So you must have documentation for them. And this considers things like bonuses, discretionary payments, differentials, etc. Basically, everything that you possibly pay to employees should be part of a written policy. You should have a trail for it, and it needs to be now organized in a way that is nice and clean for an auditor and that is nice and defensible if there's a question later about whether or not you've paid it and where it fits in. I had an all-day mediation yesterday for a class action lawsuit related to home health aides who did live-ins almost a decade ago at this point. And sure enough, the other side was seeking wage parity benefits to be paid as part of the settlement. And we're going back to the years when it was $4.09 per hour. And they tacked that on to every single hour, not just the 11 hours that are allegedly missing from the compensation for the live-in cases. And I had to explain how wage parity works to these plaintiffs' attorneys who are representing a lot of people and seeking millions and millions of dollars, and yet they do not understand how it all works together and how it comes together. And I found myself talking about spread of hours as well and why that's not owed in that case either. My point is, you need to have some document where you put it all together, not just for the auditor, but for the aides. And they need to have that translated, and that shouldn't be a problem these days with Google Translate and such tools. But transparency is absolutely required and encouraged by the state. It works significantly in your favor if you have it all in a nice, clean document. And as I said earlier, you do not necessarily have to pin yourself down to a very rigid structure. There's room in policies for you to pay bonuses to caregivers who, whatever the reason is, right? Maybe they're performing 99% compliant with EVV or whatever the case is. Maybe they're helping you recruit people because they're bringing all of their friends and family to work and become certified as an aide. Whatever the case is, whatever that additional bonus or incentive is that you're paying them, you should be taking credit for that and minimizing your 254 or $1.67 obligation. Okay, let me see what questions we have. Oh, actually, you know what? Before I do that, excuse me, I'm just going to share my screen one more time. For those of you who just want to take my information, feel free to reach out afterwards if you're not comfortable asking. I never know which of these chats are, who can see what in the chat. So I'm going to actually exercise some discretion in what I answer, and I encourage you to exercise some discretion in what you put out there because it might be a question that's visible to everybody, and you might not want everybody to know what you're asking about. But this is my contact information if you need to reach me afterwards. For those of you who are interested in listening to some potentially FAQs, please stick around. For those of you who have all of your questions answered, thank you so much for tuning in. I will say goodbye to you now and be on the lookout for our next law firm webinar. Thanks so much. All right, so let's see what questions we have. Actually, not too many questions. Okay. So for these other years, 21 through 2024, the DOH responded and said that the deadline is October 1, 2026. Share the presentation. Please email me and I will share the presentation slides. The question next was if we previously provided the LS300 forms, but during this audit we find it necessary to correct. Should we prepare new forms for those years and submit to MLTCs again? I would really have this conversation under attorney-client privilege. If you have in-house counsel, I would first talk in-house with your attorneys. Um, there's likely to be questions about why you're resubmitting things. When you submitted them, there was a representation that you've done your due diligence and researched things and did them correctly. So if they come back to you, they could come back and say, so what happened? Did you lie the last time or were you just sloppy with your work product? Why are you amending this? So I would be very leery about the impression that resubmission might create unless you believe that it was something blatantly wrong and it was just a user error or maybe a ill-advised auditor that had helped you prepare it. Unless you have a pretty good explanation and you risk being accused and prosecuted for fraud for submitting an earlier one that was not correct, I would rethink it. There's a question about holiday policy and how many holidays we have to offer to the HHAs. There's no legal requirement to offer and pay for holiday work. All right, so this is entirely by policy, meaning neither the federal government nor the state government mandates the provision of holiday pay. You could certainly pay employees who work on holidays just their regular rates, overtime, if you follow the overtime in effect rule, but there's no requirement to actually pay it. You might have a hard time finding people to work for just their regular rate on holidays because a lot of agencies do pay holiday premium. And some to this day, because they can get out of the contract, pay double time. Let's see. The question is, are annual audited financial statements a good supporting document for the LS301? Yes, I believe they are. I do believe that they are, and I thought I saw something that said you don't have to go that far because those are even more strenuously completed, but I believe that they will suffice. I will not be sending the recording automatically. You have to request it. Next question. Let's see. That's it. Looks like we have a different box. This is more of a comment than a question. This seems as if the CPA should have a deep background with the healthcare field, very specialized, and would seem to be very costly service. I absolutely agree, it would be costly. But I would say that it's not just healthcare. Healthcare is a huge spectrum, right? Someone who specializes in cost reports for nursing homes or ALPS is going to have a completely different framework that they use to audit those clients versus someone working in home care. So not just healthcare, Mr. Questioner, but home care specifically. There's a question, can wage parity benefit cover paid sick leave? Yes, it can. I'm not sure I understand this one. Sorry, there's a question about the days and to attest something, but what would I advise? Not advising anything, right? Especially, so there's an anonymous question here. Not advising anything, right? There's no attorney-client advice here being given. This is for informational purposes only. For holiday policy, PTO policy, etc., is the employee handbook sufficient, or should there be standalone policies for all of these? So this is a good question. It doesn't matter if it's in the handbook or standalone, as long as it's clear, complete, and thorough. Um, like I was saying earlier, the issue with the holiday policy is that it doesn't often say the value of the accrual. Um, if you're taking based on the comp that you're paying, for example, if you're taking a 65-cent credit for the accrual of the 56 hours of sick time, that's usually going to be on the LS62, but it's not going to be in the policy. And then, as I was saying, it's unclear if you've updated your payroll system from the prior year to be doing 65 cents credit and accrual versus what you had last year based on an old, outdated minimum wage. So all of these things kind of have to come together, but it doesn't matter if they're in a single handbook or in multiple policies. All right, now we're getting so many questions. Okay, let's see. Can the accrual wage parity amount be count for LS300? I'm not sure I understand this one. There's a few of these here I don't understand. So I apologize. I would like to help you, but if you could email them to me, I would appreciate it. And then if I need clarification, I can ask you instead of calling out here. Okay, so with that, I will thank you all for attending once again. I hope it was very helpful. And again, please feel free to reach out if you have any more follow-up questions. Have a good day.